You're watching The Legal Breakdown. Glenn, we've got some news here. Elon Musk has failed in his effort to move his case from the Philadelphia DA's office into federal court. The first thing that popped into my mind when this happened is that this is a bad look for Elon because, of course, his effort to try to move this into federal court was him banking on this idea that Donald Trump was going to win the 2024 election. And so if Trump becomes president, then he can just use his power as president and get his attorney general to just withdraw any case in federal court against Elon. Is that what he did this for? Is that what we're looking at here?
Yeah, Brian, that's the perfect question. And this is a little bit complicated, but it looks like even billionaires can't buy their way out of trouble. Because here's what happened. The district attorney for Philadelphia brought a legal challenge to, Elon Musk doing what we all know he's trying to do at the bottom of it all. He's trying to buy votes, right? He's trying to convince people by dangling all sorts of money in front of them that they should vote for Donald Trump. Now, that's not precisely what Elon Musk said he's doing with this $1 million a day lottery. No. I'm just trying to get people to sign my petition saying they support the First and Second Amendment. Well, what a bunch of nonsense. But here is where we are, and this is not intuitive, so the viewers will have to kind of stick with me here for a minute. Ordinarily, if somebody is charged in federal court, whether charged with a crime or they're being sued, as Elon Musk is being sued by the district attorney for Philadelphia, and they may have some reason to try to get it moved into federal court. Usually that reason is the person being sued or being charged is a federal government official, so they want to be tried or sued in federal court. Why? Because they might have additional federal defenses that would be available to them in federal court that might not be available to them in civil court. And this one also, Brian, I have a feeling, Elon Musk thought it might be better to get this in front of a federal judge instead of a local Pennsylvania or Philadelphia judge, maybe hoping that judge might have been somebody appointed by whom? Donald Trump, right? That might go a little bit better for Elon. So Elon Musk's thinking might go. But it looks like the federal court rejected Musk's attempt to jump from the Pennsylvania state courts into federal court. So you raised the idea of, well, maybe if Elon could get his case over in federal court and Donald Trump gets elected, Donald Trump could make the case go away. That is kind of a natural understanding of what a president can do if he, like Donald Trump, would be willing to misuse his Department of Justice. So, for example, if it were a criminal case, he could just tell his attorney general, just dismiss that case. If it was a civil suit, he might be able to tell his attorney general, I want the federal lawyers to just not pursue that civil suit. Here's the thing people may not realize. When a case starts in state court, if it successfully jumps into federal court, guess what? It is still a state case, albeit a state case that will be tried in federal court with the defendant or the respondent in the civil case having some additional federal defenses potentially available to them. So it is a myth. It's a myth that I often hear people discuss, understandably so, that if a case goes from state court to federal court, it must become a federal case. No, just like, remember when Donald Trump was endlessly trying to get his New York State prosecution, in which he's now been convicted of 34 felony counts for falsifying business records to cover up hush money payments to try to steal the 2016 election. Donald Trump was endlessly and repeatedly trying to get that transferred over to federal court, but he was unsuccessful. If he had been successful, guess what? He still would have been prosecuted by Alvin Bragg's New York State Court prosecutors, because it doesn't magically morph into a federal case where all of a sudden federal prosecutors come galloping in to prosecute the case and a dirty attorney general, a federal attorney general, could dismiss that case. No, remains a state case. So I know there's a lot of layers going on in this story, but ultimately let's not bury the lead. And you started with the lead, which is that Elon Musk lost. He tried to get his case transferred from Pennsylvania state court into federal court, and the federal judge said, nope, you're going to have your case tried and heard in Philly court.
Glenn, some other news here that's breaking at the time of this recording is that the Philadelphia judge has scheduled a hearing in the DA case against Elon Musk, and that hearing is going to be on Monday, November 4th at 10 a.m. Eastern. What do you make of the fact that this thing is going to be right on the eve of the very election day that Elon Musk was trying himself to buy for Trump?
Yeah, you know what, Elon? Happy Election Day Eve, because you'll be celebrating by being in court trying to defend yourself against what is pretty dirty conduct, whether or not you end up losing the suit. I think, you're not fooling anybody. This is dirty conduct designed to interfere in a presidential election. And look, let's face it, Elon Musk can probably buy the city of Philadelphia 10 times over with his, boatloads of money. But that doesn't necessarily mean that the judges and the district attorneys and the attorneys from Philadelphia who are pursuing this case against Elon Musk aren't going to win just because Elon is filthy rich and determined to do his nefarious best to help his boy, Donald Trump, try to win this election. So, you know what? I will definitely be keeping one eye on the reporting coming out of that Philadelphia courtroom on election eve to see how it's going for Elon Musk.
Does Elon himself have to be there for this first hearing?
No, in civil cases, ordinarily the plaintiff, if you bring the case, or the respondent, if the case is brought against you. So Elon Musk would be the respondent. Sometimes we call that person a defendant. Ordinarily, unless a judge specifically orders that person to be present, which rarely happens in civil cases, the respondent doesn't have to be there. Think back to the E. Jean Carroll case. I think the first E. Jean Carroll case, the trial unfolded and Donald Trump didn't even bother attending a single day. And of course, that jury banged him out for $5 million in damages. So it didn't play out so well for Trump just ignoring that civil suit that was brought against him. But no, ordinarily the civil litigants don't need to be present for the courtroom proceedings.
And Glenn, based on what you know about this case as it stands right now, what Elon Musk has done, what the laws and statutes are regarding creating a lottery in Pennsylvania, do you think that this will be something of a successful litigation effort against Elon Musk?
I'm not going to pretend to be an expert on Pennsylvania state lottery law. I wouldn't even hazard a guess because I would probably be wrong. However, here's what I will say. The district attorney for Philadelphia believed he had a meritorious suit to bring. I have to believe that that office and his staff, Larry Krasner is the district attorney, his staff, really drilled down on the statutes involving illegal gaming as they intersect with election law. And they had to, come to the conclusion that they had a really strong case to bring against Elon Musk, or I can't imagine they would have brought it. Now, a lot of people have observed, why in the world hasn't Merrick Garland brought a federal case? Because it looks like, if he's violating Pennsylvania state law in the election arena, isn't he violating federal law, given that this really is a federal election? And the answer is maybe yes, maybe no. Now, remember, Merrick Garland did send a strongly worded letter shaking his finger at Elon Musk saying, cut it out, which leads me to believe the Attorney General would only do that if he had the law to back it up. But I have no doubt that there are differences in the laws in Pennsylvania versus on the federal books involving gaming, lotteries, as that intersects with election law. So it may be that Philadelphia and the state of Pennsylvania has the more favorable laws, and so the more winning suit that they can bring, and maybe that's why the feds are taking a back seat. I don't know that for a fact, but again, we're going to learn more probably come November 4th and in the days and weeks thereafter.
It could be that they have more favorable laws, or it could be that there is the timidity of the DOJ that we're contending with right now. Glenn, let's finish off with this. Do you think that just by virtue of the sheer amount of resources and money that Elon Musk has at his disposal, Philadelphia DA's office has to know that? They have to know that they're going to be contending with a major adversary in this litigation. And so do you think that they had to take into account that their case here has to be as close to airtight as possible if they're going to engage in this thing, knowing that their opponent, the respondent in this case, literally has every resource available to man and that he can throw at them. And so does the fact that they are moving forward with this case anyway, is that a testament? Can we glean something from that in the sense that they know how good their case is? Because otherwise it just wouldn't be worth it to waste all of their resources against somebody who can tie them up, who can spend all of his money against them.
Yeah, I'm going to have to answer that question by saying yes and no. First of all, when I was making a decision whether to bring charges, whether to ask a grand jury to indict somebody, whether to prosecute somebody, I didn't care how much money they had or did not have. I didn't care if they were high profile, low profile, or no profile folks. None of that mattered. The facts and the law are the only thing that mattered, and that's what drove my prosecutorial discretions and decisions. So I would like to think all prosecutors operate that way, and I have reason to believe that most of us do. But I think I'd be naive not to say, they had to really be confident and comfortable in the case they were bringing, because they knew they'd be bringing a suit, a legal challenge against somebody with endless resources to try to defend themselves and make mischief in the process. For example, by trying to delay this thing, to the hilt. So I don't know. I think it's a mixed answer of yes and no, but I have to believe that the lawyers in the the Philadelphia District Attorney's office are feeling pretty confident and comfortable with the evidence, the facts, and the law.
Well, this thing is moving ahead pretty expeditiously here in the Philadelphia court system. So we will, of course, stay on top of it. As soon as there are any updates, we'll bring them to you. For those watching, if you want to follow along, please make sure to subscribe. The links to both of our channels are right here on the screen, and that is the best way to support our work. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.